Welcome to this deep dive, brought to you by Sinorbit Academy, Sri Lanka.
Hello.
Today, we're tackling the foundational principles of EU law,
That's right.
and we're drawing from materials made available to students by the University of London. These are for educational purposes only, of course.
Absolutely. Our mission today is really to unpack these complex ideas.
Yeah, so you, the learner, can really grasp how EU law impacts national legal systems. It's crucial stuff.
It really is. And a big good luck to all of you gearing up for your exams.
Definitely. Good luck, everyone.
So in this deep dive, we're going to look at, well, several key areas.
Okay, what do we got?
We'll cover direct effect, then indirect effect, remedies for union law rights, that's a big one. Then state liability, the principle of supremacy of EU law,
The big one.
how that actually lands in different member states, which can be tricky. And finally, those overarching general principles.
Okay.
And the aim isn't just to list them, but to give you a real feel for how they work and, how to approach studying them effectively.
Perfect. So let's dive straight in. Direct effect.
Right.
This is, well, it's a game changer, isn't it? The idea that you, as an individual, can actually lean on EU law, enforce it in your own national courts.
Exactly. It's not just state to state. It empowers individuals directly.
Which is huge.
And the case that really ignited this whole thing was Van Ghent on Loos, way back in 1963.
Van Ghent on Loos. Okay, let's hear the facts.
Okay, so think about this. A company, Van Ghent on Loos, they're importing urea formaldehyde, a chemical from Germany, into the Netherlands.
Right.
And suddenly they get hit with a higher customs duty than they expected.
Right.
An increase.
Okay.
So they challenged it. They pointed to what was then Article 12 of the EC Treaty. It's Article 30 TFU now,
Yeah.
which basically said no new customs duties or increases, a clear prohibition.
And this, just a simple import duty issue, it went all the way up and fundamentally reshaped how we see EU law.
Absolutely. This is where it gets really interesting. The Court of Justice, the ECJ, declared that the European Community wasn't just, a club of states.
It was more.
It was a new legal order, that's the phrase, a new legal order where member countries had willingly limited some of their sovereign rights.
Okay.
And crucially, this new order directly impacted individuals, giving them rights they could actually enforce themselves in their national courts.
Wow. So Van Ghent on Loos, the birth of this new legal order idea and individual rights from EU law.
Precisely. Before Van Ghent on Loos, international treaties, mostly the business of states talking to states.
Right.
This was revolutionary. It said, hey, some EU law provisions give rights directly to people and companies.
So what were the conditions? How does a provision get this direct effect?
Well, the court initially set out some key hurdles. The provision had to be clear and unconditional.
Clear and unconditional.
And it shouldn't need any further action, any implementing measures from the national government to be effective.
Self-executing, basically.
Exactly.
Yeah.
Self-executing. They even mentioned it initially had to be a negative prohibition, a sort of don't do this rule, but, well, that bit was relaxed later on. So, for your studies, remember those core initial conditions. Clear, unconditional, and self-executing. That's your starting point for direct effect.
Right. So that's the checklist. Is this piece of EU law clear? Are there no conditions attached? Does it work straight away without the government needing to pass another law? But you said this evolved. It's not quite that simple anymore.
Exactly. The focus sort of shifted over time. It became more about whether a provision is justiciable.
Justiciable meaning?
Meaning, can a national court actually understand it and apply it in a real legal fight? Is it capable of being applied by a court?
Okay, makes sense.
And it's fascinating to see how this played out across different types of EU law, like treaty articles, for instance.
Right, the treaties themselves.
Yes, they can have direct effect. And a really important distinction emerged here, vertical versus horizontal direct effect.
Okay, vertical versus horizontal, what's the difference?
Vertical direct effect is when you, an individual or company, are using EU law against the state or an arm of the state. Like in Van Ghent on Loos itself, the company versus the Dutch Customs Authority.
Okay, individual versus the state. Got it.
Horizontal direct effect is when the argument is between private parties, two individuals, or two companies.
Ah, okay. So not involving the state directly.
Precisely. And the landmark case for horizontal direct effect, specifically for treaty articles, was Defren v. Sabina.
Defren v. Sabina. That rings a bell. equal pay.
Exactly. Equal pay for male and female cabin crew, a fundamental principle of equality in the treaty. And Mrs. Dufresne used that article directly against her employer, Sabina, a private airline.
So that showed treaty articles could bite even between private parties. That's quite something.
He really demonstrated the potential reach, yes.
Okay, so treaty articles can have both vertical and horizontal direct effect if they meet the conditions. What about regulations?
Regulations. Now, Article 288 TFEU is pretty strong on these. It says regulations are directly applicable in all member states.
Directly applicable. That's like an automatic direct effect.
Well, generally, yes. Directly applicable means they automatically become part of national law. You don't need a separate national law to bring them in. And in principle, you can rely on them in national courts.
But there's a but, isn't there?
There often is. Even regulations aren't completely immune from needing to be clear and unconditional enough for a court to actually enforce them. The Hacienda Agricola Monte Arcosu case highlighted this.
Hacienda Agricola Monte Arcosu.
Okay. And there have been cases like Commission v. Italy, the slaughtered cows case, as it's known,
Right.
and Commission v. UK about tachographs in trucks, where the court found that even though they were regulations, they actually needed some further national measures to really work properly in practice.
So directly applicable doesn't automatically mean directly effective in every single situation. That's a key nuance for exam.
Absolutely critical nuance.
Okay. What about international agreements? Trade deals the EU signs with other countries, they're part of EU law. But can I use them directly in, say, a UK court? Seems complicated.
It can be, yes. The court has generally been, well, more cautious about giving direct effect to provisions in big international agreements like the GATT, the General Agreement on Tariffs and Trade.
Why cautious?
Well, the reasoning often goes that these agreements have a different nature, a different purpose, compared to the EU treaties themselves. They're more about relations between states, maybe less precise, maybe dependent on reciprocal action. We saw this in the International Fruit Company case regarding GATT.
International Fruit Company. Okay.
Similarly, free trade agreements, like the one in the Polydor case involving record imports, were usually held not to have direct effect. The main goal wasn't deep integration like the single market.
So usually no direct effect for these big agreements.
Usually, but the Kupferbrunn case showed it wasn't an absolute no. Yes. It suggested that if a specific provision within such an agreement does happen to be clear, precise, unconditional, and fits with the agreement's aims, then it could potentially have direct effect.
So a possibility but conditional.
A possibility, yes. And in Germany v. Council, the court also made it pretty clear that GATT rules would only very rarely take precedence over specific EU laws.
So for international agreements, it's really a careful, case-by-case look at the wording and the specific purpose.
Got it. What about decisions? They're binding on whoever they're addressed to.
Yes, exactly. Decisions are binding in their entirety on those named.
Can individuals use them directly?
Yes, they can. The court established this in cases like Grad v. Finanzam Traunstein.
Grad, okay.
If a decision is addressed to a member state, an individual within that state can invoke it in their national court, provided, again, it's clear, precise, and unconditional enough. The court basically said this boosts the effectiveness of EU law.
Makes sense. Okay, now, directives. This is often where students get a bit tangled up.
Understandably so. Because directives tell member states the result to achieve, but leave them the how, the form, and methods. They usually need national laws to implement them. So how can they have direct effect?
That is the million-euro question, isn't it? Article 288 TFEU is clear. Binding as to result, but choice of form and methods for national authorities.
Right.
So the initial thinking was, well, they need national implementation, so no direct effect. Simple.
But the court didn't leave it there.
No, it didn't. The massive case here is Van Dyne v. Home Office.
Van Dyne. Scientology case.
That's the one. Miss Van Dyne wanted to come to the UK to work for the Church of Scientology. The UK tried to refuse her entry based on public policy.
Okay.
She argued this refusal violated a directive on the free movement of workers. Now, the UK hadn't fully implemented the relevant parts of that directive in the way needed for her situation.
So the directive wasn't properly law in the UK yet in that respect.
Correct. But the court said, hang on, if a provision within a directive is sufficiently clear, precise, and unconditional, an individual can rely on it against the state, even if the state hasn't implemented it properly or on time.
Wow. So the state's failure doesn't block the individual's right derived from the directive itself?
Exactly. That was the breakthrough in Van Dyne.
So Van Dyne established direct effect for directives. But there's a big catch, isn't there? This effect, it's usually only vertical.
Precisely. This is a crucial limitation. The court developed this idea, sometimes called the estoppel argument, which we saw clearly in Publico Ministero v. Ratti.
Ratti, okay, estoppel.
The basic idea is that a member state shouldn't be able to rely on its own failure, its failure to implement a directive correctly or on time, to deny rights to individuals that the directive was meant to give them. It's stopped or prevented from benefiting from its own wrongdoing.
So because the state failed, it can't then turn around and say, well, the directive isn't national law, so you can't use it against me.
Exactly. So direct effect of directives is primarily vertical. You use it against the state or an emanation of the state.
Emanation of the state. That sounds like legal jargon. What does it mean?
It basically means bodies that are, in effect, arms of the state, even if they aren't government departments. The key case defining this is Foster v. British Gas.
Foster v. British Gas. Privatized utility.
Yes. The court set out criteria. Is the body performing a public service? Is it under state control? Does it have special powers beyond normal commercial undertakings? If yes, it might be an emanation of the state, and you can use a directive against it vertically. The Farrell case more recently clarified these criteria.
Okay, so the definition is quite broad, potentially, but the key point remains. You generally cannot use the direct effect of a directive against another private individual or company.
That's the general rule, yes. No horizontal direct effect for directives. The court confirmed this in cases like Marshall v. Southampton, AHA, another discrimination case, and Ficini-Dori.
Marshall and Ficini-Dori confirm no horizontal direct effect for directives.
It can feel a bit unfair sometimes, right? Your rights depend on who you're suing.
It can seem that way. The court's reasoning is partly based on the wording of Article 288 Barties. Directives are addressed to member states. Imposing direct obligations on private individuals through an unimplemented directive was seen as going too far, potentially undermining legal certainty for those individuals.
Okay, so when does this direct effect kick in? After the deadline for implementation has passed?
Yes, generally. As the Ratti case established, the state gets its chance to implement the directive by the deadline. If it fails, then individuals can invoke direct effect vertically, assuming the conditions are met.
But is there any obligation before the deadline?
Yes, there is. The Inter-Environment Wallonie case introduced what's called a standstill obligation.
It means that during the period between the directive entering into force and the deadline for its transposition into national law, member states must refrain from taking any measures that could seriously compromise the achievement of the result prescribed by the directive. They can't actively undermine it before they've even implemented it.
Okay, that makes sense. So let's nail this down for exam purposes. Directives can have direct effect if clear, precise, unconditional
Correct.
implementation deadline must have passed.
Yes.
And crucially, the effect is generally only vertical against the state or an emanation of the state.
That's the core summary. Now, there are some very limited exceptions, these sort of incidental horizontal effects in specific triangular situations.
Like CIA Security or Unilever Italia.
Exactly,
Yeah.
where applying EU law might indirectly affect the legal position between private parties, but it's not a direct enforcement of the directive's obligation by one private party against another. They're quite specific, though.
Okay, good to be aware of, but the main rule is vertical only.
Yes. Now, what happens if direct effect isn't available? Say, the provision isn't clear enough, or you're in a horizontal situation with a directive. Is that the end of the road?
Ah, good question. This leads us to indirect effect, doesn't it?
Precisely. Indirect effect, or the duty of harmonious interpretation, another crucial tool developed by the court.
Harmonious interpretation. So what's the principle?
The key case here is von Colson v. Land Nordrhein-Westfalen, another discrimination case.
Von Colson. Okay.
In that case, the remedy provision in the Equal Treatment Directive wasn't considered clear and precise enough for direct effect. But the court said, hold on, national courts still have a duty.
A duty to do what?
A duty to interpret their existing national law, all relevant national law, as far as possible, in the light of the wording and purpose of the directive in order to achieve the result the directive intended.
So even if the directive itself doesn't give me a direct right I can sue on, the national court has to try and read existing national laws in a way that aligns with the directive's goals.
Exactly. They have to try and make national law fit the directive within the bounds of interpretation. This duty comes from the principle of sincere cooperation between the EU and member states, now in Article 4.3 TEU.
And this applies to all national legislation, even laws passed before the directive.
Yes. The Marleeson case made that clear. It doesn't matter when the national law was passed or even if it was specifically intended to implement the directive. The duty applies.
Marleeson.
Yep.
Okay. And does this work horizontally, too, between private parties?
Yes, it does. Because the duty is on the national court to interpret the law, it applies regardless of whether the parties are private individuals or the state. So indirect effect can work in horizontal situations where direct effect of directives cannot.
That's a really important difference. Indirect effect fills a gap left by the limits on direct effect for directives.
It certainly helps, but there are limits to indirect effect too.
Okay. What are the limits?
Well, the big one is in the phrasing. Interpret so far as possible. Meaning, if the national law is completely unambiguous and directly contradicts the directive, the court can't just rewrite the national law. Interpretation has its limits. Or, if there simply isn't any relevant national law to interpret, indirect effect can't help.
Can't interpret thin air.
Exactly. Also, the court stressed in cases like Kulpingwis that this interpretation must respect general principles of law.
Such
as legal certainty and non-retroactivity. You can't use indirect effect to distort national law in a way that fundamentally undermines these principles.
And crucially, what about criminal law?
Very important point. The court has consistently said, in cases like Arcaro and later confirmed in Berlusconi, that the duty of harmonious interpretation cannot be used to create criminal liability where it didn't exist under national law, or to make existing criminal liability worse.
So no contra legem interpretation in criminal matters.
Correct. You can't use indirect effect to impose or aggravate criminal penalties against individuals based solely on an unimplemented directive. That would breach legal certainty and non-retroactivity principles.
But it can impose civil liabilities.
Yes, it can. Cases like Centrosteel and Oceano Grupo Editorial show that indirect effect can lead to civil liabilities being imposed between private parties based on interpreting national contract law, for example, in line with a consumer protection directive.
Okay, so it's a powerful tool, indirect effect, works horizontally, applies to all national law, but it has limits. Can't rewrite clear law, respects general principles, and crucially, can't create or worsen criminal liability.
That's a very good summary. And you can see how national courts, like in the UK cases you mentioned earlier, Pickstone, Webb, have really grappled with applying this duty, sometimes stretching interpretation quite far.
Right. So we have direct effect, indirect effect. But what about the actual remedies? If I have a right under EU law, how do I actually get compensation or stop something from happening?
Good question. The general starting point, the default rule, is that remedies are governed by national law.
So EU law gives the right, but national courts provide the fix using their usual procedures and remedies.
Largely, yes. There isn't, generally speaking, a separate system of EU remedies enforced through national courts' state liability, which we'll get to, is a bit different. The Ruhandelsgesellschaft Nord case established this principle, national procedural autonomy.
Okay. But surely the EU doesn't just leave it entirely to national law. What if national remedies are useless?
Exactly. The court quickly realized that national autonomy couldn't be absolute. So it laid down two fundamental principles that national remedies must comply with when enforcing EU law rights. These come from cases like Ruiz Central Finance and Comet BV.
Two principles. What are they?
First, the principle of equivalence. National procedures and remedies for EU law claims cannot be less favorable than those for similar domestic claims. You can't have a really difficult process for an EU right claim if there's an easy one for a similar national right claim.
Equivalence. Fair enough. What's the second?
Second, the principle of practical possibility or effectiveness. National rules must not make it virtually impossible or excessively difficult to exercise rights conferred by EU law. The remedy has to be real, not just theoretical.
Equivalence and effectiveness. Got it. Make it fair and make it actually work.
Precisely. And later cases, like von Coulson again, added another layer, emphasizing that remedies need to be effective not just in theory, but also adequate, providing proper compensation, for instance, and have a deterrent effect to ensure EU law is respected.
And the Factortame cases, the Spanish fishing boats saga in the UK, really hammered home this effectiveness principle, didn't it? Especially regarding interim relief.
Absolutely. Factortame was monumental. It established that national courts must have the power to grant interim relief, temporary orders to protect rights while a case is ongoing, even if it means temporarily setting aside a rule of national law that would normally prevent such relief.
Even setting aside an act of parliament. in the UK context.
Yes. The court said the full effectiveness of EU law demands that national courts can provide immediate protection for potential or putative EU law rights, overriding any conflicting national rule.
So effectiveness can even require national courts to disapply their own laws temporarily. That's powerful.
It shows how seriously the court takes the enforcement of EU rights. Other cases illustrate this too. Marshall, number 2, insisted on full compensation for discrimination, no arbitrary caps, and including interest.
Marshall, number 2. Right.
Johnston v. RUC confirmed the need for effective judicial review even when national security was invoked. And UNACTEF v. Halens established a duty for national bodies to give reasons for decisions affecting EU rights so people can challenge them properly.
Okay, so effective remedies are key. But what about national procedural rules like time limits? Can they trip you up?
They can, and the court has wrestled with this. The Emmett case initially seemed very protective of individuals. It suggested that national time limits for bringing a claim based on a directive wouldn't start running until that directive had been properly transposed into national law. Because how can you know your rights and the time limit if the law isn't even properly in place?
That sounds logical.
It does, but it caused practical problems. Later cases, like Steenhorst-Neerings, seemed to pull back from Emmett's absolute stance. They allowed national rules, for example, limiting the retroactive effect of benefits claims, as long as those rules still complied with the core principles of equivalence and effectiveness. So it's more of a balancing act now.
So national procedural rules generally apply, but they can't be discriminative to equivalence or make it practically impossible to claim your EU rights effectiveness.
That's the essence of it. And the Lisbon Treaty strengthened this area further. Article 19.1 TEU explicitly requires member states to provide remedies sufficient to ensure effective legal protection in fields covered by union law.
Article 19 TEU.
And the Charter of Fundamental Rights in Articles 47 and 51 guarantees the right to an effective remedy. We saw this applied in DEBV Germany, ensuring companies could get legal aid to pursue state liability claims.
Okay, and that mention of state liability is a perfect segue. This is another huge development by the court, right?
Yeah.
Suing the state itself for damages if it breaches EU law.
Absolutely huge. And like direct effect for directives, this wasn't explicitly written into the original treaties. It was developed by the court.
Why did they develop it?
Primarily to ensure EU law is effective and to protect individuals who suffer loss because a member state failed to comply with its EU obligations. It provides a remedy, particularly where direct effect might not be available or sufficient. The foundational case is Frankovic.
Frankovic, Italy and the Insolvency Directive.
Exactly. Italy failed completely to implement a directive meant to guarantee payment of wages to employees if their employer went bankrupt. Mr. Frankovic and others lost out.
So they couldn't rely on the directive directly because parts weren't clear enough and they couldn't use indirect effect, perhaps.
Right. So the court said, well, there must be another way. It declared that the principle of state liability for loss caused to individuals by breaches of EU law for which the state is responsible is inherent in the system of the treaty.
Inherent? Wow. Based on what?
Based on the duty of sincere cooperation, now Article 4.3 TEU, and the fundamental need for EU law to be effective. If states could breach EU law causing harm without consequence, the whole system would be undermined.
So Frankovic established the principle of state liability specifically for non-implementation of a directive. What conditions did you need to meet?
The court set out 3 conditions in Frankovic. First, the directive must involve rights granted to individuals.
Okay.
Second, the content of those rights must be identifiable just by looking at the directive's provisions.
Fair enough.
And third, there must be a direct causal link between the state's failure to fulfill its obligation, not implementing the directive, and the loss suffered by the individual.
Right. Identifiable content, causal link. The Frankovic conditions.
Correct. For failure to implement a directive.
But state liability wasn't limited just to that specific failure, was it? What if the state implements the directive, but does it wrong, or breaches a treaty article?
Exactly. The court quickly expanded the principle. The joint cases of Brasserie du Pêcheur and Factor Team Third were crucial here.
Brasserie du Pêcheur and Factor Team Third.
Okay. These cases extended state liability to cover any breach of union law by a member state, whether it's legislation, an administrative action, or even inaction, provided certain conditions are met. And the conditions were aligned more closely with the EU's own liability under Article 340 TFEU.
Okay, so what are these blotter conditions, the brasserie de pêcheur conditions?
3 conditions, again, slightly different focus. First, the rule of EU law infringed must be intended to confer rights on individuals, similar to Frankovich.
Right.
Second, the breach must be sufficiently serious. This is the key addition.
So sufficiently serious, what does that mean?
It means the member state must have manifestly and gravely disregarded the limits on its discretion. It's quite a high bar. The court gave factors to consider. How clear was the rule? How much discretion did the state have? Was the breach intentional? Was there excusable error? Did EU institutions contribute to the confusion?
Okay, so it's not just any minor error. It has to be a significant failure.
Generally, yes. Although, importantly, the Dillenhofer case clarified that a complete failure to implement a directive by the deadline is always considered a sufficiently serious breach. So Frankovich liability fits neatly within the brasserie framework.
Dillenhofer confirms non-implementation is always serious enough.
Got it. And the third condition?
Same as Frankovich.
Yeah.
A direct causal link between the sufficiently serious breach and the damage suffered by the individuals.
Right. Sufficiently serious breach, causal link. The brasserie du pêcheur factotem third, conditions for general state liability. Exactly. And remember, the actual procedure for bringing a state liability claim, which court, what evidence, etc., is governed by national rules, subject always to those principles of equivalence and effectiveness we discussed.
Right. And we saw in the British telecommunications case that even incorrect transposition might not be sufficiently serious if the directive itself was genuinely unclear or ambiguous.
Yes, that shows the sufficiently serious test in action. It requires a significant disregard of EU law.
And this liability can apply to various public bodies, right? Not just central government.
Yes. The Haim case confirmed liability could attach to public law bodies. And perhaps most controversially, the Kubler case established that, in very exceptional circumstances, a state could even be liable for a decision of its highest court if that court manifestly infringed EU law.
Kubler liability for judicial decisions, that must have a very high threshold.
Extremely high. The court emphasized the need to protect judicial independence and legal certainty, res judicata. It really has to be a manifest, undeniable error by the final court. It's rare.
Okay, so direct effect, indirect effect, state liability. A powerful toolkit the court has built to make sure EU law actually works on the ground.
Absolutely. It underscores the court's commitment to the effectiveness of the legal order.
Which brings us neatly to the bedrock principle underlying all of this. Supremacy, the idea that EU law trumps national law when they conflict.
Yes, the absolute cornerstone. You could say it was implicit in Van Gent en Loos and the new legal order,
Right.
but it was made explicit and forceful in Costa v. ENAL in 1964.
Costa v. ENAL, the Italian electricity nationalization case.
That's the one. The court stated unequivocally that by creating the community, member states had limited their sovereign rights, albeit in limited fields. And because of this transfer of powers, laws stemming from the treaty, from this independent source, could not be overridden by domestic legal provisions, however framed, without the legal basis of the community itself being called into question.
So EU law prevails. Full stop. Even over national constitutions.
That was the bombshell dropped in the International Handelsgesellschaft case, often known as Solange I.
International Handelsgesellschaft, Solange-Everest.
The court held that the validity of EU law measures cannot be challenged based on national law rules or concepts, including fundamental rights protected by a national constitution. The supremacy is absolute in its sphere.
Wow. That's a very strong assertion of supremacy.
It certainly is, and the practical consequence was spelled out in Simmenthal.
His Simmenthal, what did that add?
Simmenthal established the duty of every national court within its jurisdiction to apply EU law in its entirety and protect the rights it confers on individuals. And crucially, they must set aside any provision of national law which conflicts with it, whether that national law came before or after the EU law.
Set aside immediately. They don't need to wait for a higher court or the national parliament to repeal the conflicting law.
No waiting required. They must disapply the conflicting national law immediately on their own authority. This duty applies to all state bodies, too. Not just courts' administrative agencies must also disapply conflicting national rules, as the Larzy case showed.
So disapplication is the immediate remedy. But does the state still have to formally get rid of the conflicting law?
Yes. While disapplication deals with the immediate conflict, the court held in Commission v. France, French merchant seamen, that member states are obliged to formally repeal or amend national laws that clash with EU law to ensure legal certainty. You can't leave invalid laws lurking on the statute books indefinitely.
Okay. And this supremacy principle, it even extends to protecting those putative rights we mentioned with factor tame.
Yes. Factor tame showed that the need to ensure the practical effect of EU law requires national courts to set aside national procedural rules, like the UK rule preventing interim injunctions against the Crown if they obstruct the protection of rights potentially derived from EU law. Supremacy demands effective protection.
And even though supremacy isn't explicitly stated as a general principle in the current treaties, its status is pretty secure, right?
Yes. A declaration attached to the Treaty of Lisbon explicitly refers back to the settled case law of the Court of Justice regarding the primacy of EU law. And the Council's legal service issued an opinion confirming supremacy remains a fundamental principle derived from the nature of the EU legal order established by that case law.
So the court built it, and it remains foundational even without a big supremacy clause in the treaty text itself.
Precisely.
But how has this actually been received in the member states? Because that international Hausgesellschaft ruling saying EU law trumps even national constitutional rights must have caused some ripples.
Oh, absolutely. The reception of supremacy has been and continues to be a complex and sometimes contentious story across the EU. National legal systems have different traditions and constitutional frameworks.
Let's take the UK, pre-Brexit, obviously. Dualist system, right? International law doesn't automatically become domestic law.
Correct. So the European Communities Act 1972 was the crucial conduit pipe that allowed EU law to flow into the UK legal system. UK courts generally accepted they had to interpret UK law consistently with EU law, in direct effect, because Parliament told them to via the 1972 Act.
But factor tame was a big moment, accepting they had to disapply an act of Parliament.
A huge moment. It showed UK courts accepting the practical supremacy of directly effective EU law over primary legislation, something constitutional unprecedented. Though later cases like Thoburn, with its idea of constitutional statutes, hinted at potential limits or future clashes, especially concerning fundamental rights perceived to be rooted solely in UK constitutionalism.
Okay. What about Germany? They seem particularly concerned about fundamental rights.
Yes. The German Constitutional Court initially, in International Handelsgesellschaft, Solange said, okay, supremacy. As long as Solange, the EU doesn't have equivalent fundamental rights protection, we reserve the right to review EU law against our Constitution's fundamental rights.
So conditional acceptance.
Exactly. But later, in Wünsche Handelsgesellschaft, so long a second, after the ECJ had developed its own fundamental rights case law, the German court said, okay, now the EU generally provides equivalent protection, so we won't routinely review EU law against our fundamental rights as long as that protection level is maintained.
So acceptance, but still with a watchful eye.
Definitely. And the German court has consistently reaffirmed its ultimate sovereignty and its right to review whether the EU is acting within its conferred powers, the ultravirus review, famously in the Brunner case on the Maastricht Treaty, and more recently and controversially in the PSPP case concerning the ECB's bond buying program, where it actually declared an ECJ judgment non-binding in Germany regarding the assessment of proportionality.
So Germany accepts supremacy generally, but reserves the right to police the boundaries of EU power and fundamental rights protection according to its own constitution.
That's a fair summary of the tension.
How about France? Monist system, different starting point.
Yes, France is traditionally monist, meaning international law is more readily integrated. Article 55 of the French Constitution gives treaties superiority over statutes. The Cour de Cassation, highest civil court, accepted the primacy of directly effective EU law relatively early in Vabre and Weigel.
But the administrative courts were more reluctant.
The Conseil d'État, highest administrative court, was yes. Particularly regarding the direct effect of directives, the Cohn-Bendit doctrine held for a long time that individuals couldn't rely on directives against administrative acts if they hadn't been transposed. Though it did accept the primacy of regulations and eventually came around to awarding factor-tame-style damages. Often, though, the French courts tend to ground EU law's authority ultimately in the French Constitution itself.
Interesting. And Italy. Similar reservations like Germany.
Yes, Italy accepted supremacy based on Article 11 of its constitution, allowing limitations of sovereignty for international organizations promoting peace and justice in the Frontini case. But like Germany, the Italian Constitutional Court has consistently reserved the right to intervene if EU law conflicts with fundamental principles of the Italian constitutional order or inalienable human rights code. the counterlimits doctrine, seen in cases like SPA fragged.
Counterlimits.
And the recent Tarico saga really highlighted this. It involved a long dialogue between the Italian court and the ECJ about whether an ECJ ruling requiring disapplication of national statutes of limitation for fraud cases violated fundamental principles of legality in criminal law under the Italian Constitution. It showed the courts talking, but also the potential for deep disagreement.
So another example of qualified acceptance, what about newer member states, like Poland?
Poland's situation has become particularly complex. Initially, the Polish Constitutional Tribunal accepted the primacy of EU law, where powers had been transferred, based on Article 91 of the Polish Constitution, while stating the Constitution remained the supreme law, K1804.
But that changed.
More recently, particularly in a highly controversial decision in 2021, K321, the Polish Constitutional Tribunal challenged the primacy of key EU treaty provisions, including those concerning judicial independence under Article 19 TEU, finding them incompatible with the Polish Constitution in certain aspects. This decision has been heavily criticized by many legal scholars and EU institutions as undermining the foundations of EU law and raised serious rule of law concerns.
So a direct challenge to supremacy from a national constitutional court.
A very significant one, yes. It highlights that while the ECJ asserts supremacy as uniform and absolute, its reception and effective application on the ground in member states can be varied and, in some cases, highly contested, often through the lens of national constitutional identity.
It's a fascinating dynamic. Okay, finally, let's briefly touch on the general principles of EU law. We've mentioned them a few times.
Yes, these are fundamental, unwritten principles that permeate the EU legal order. Think of them as guiding lights.
Where do they come from?
They're derived from various sources, implicitly from the treaties themselves, from the constitutional traditions common to the member states, and increasingly from international human rights law, especially the European Convention on Human Rights, ECHR.
And what do they include? We've mentioned proportionality, legal certainty.
Exactly. Proportionality, legal certainty, including legitimate expectations and non-retroactivity, equality and non-discrimination, subsidiarity, fundamental rights themselves are now seen as general principles, procedural fairness, like the right to be heard, duty to give reasons.
And who do they bind?
They primarily bind the EU institutions. EU legislation or decisions can be challenged and annulled by the Court of Justice under Article 263 TFEU if they violate a general principle.
So they act as limits on EU power.
Yes, but they also bind the member states, but only when they are acting within the scope of EU law.
What does that mean, within the scope of EU law?
It means when member states are implementing EU law, like transposing a directive, or when they are derogating from an EU freedom, like restricting free movement for public security reasons. In those situations, they must respect the general principles of EU law, including fundamental rights as interpreted by the ECJ.
Okay, so if a member state restricts free movement, that restriction has to be proportionate.
Precisely. The Omega Spielhallen case is a good example. Germany restricted the freedom to provide services, a laser game, based on protecting human dignity under its constitution. The ECJ accepted this could be a legitimate justification, but the restriction had to be proportionate to that aim. Proportionality is a key balancing principle.
And legal certainty. We saw Kirk on non-retroactivity of criminal penalties.
Yes. And topper on protecting legitimate expectations, individuals should be able to rely on the law as it stands. Equality is another huge one. Article 18 TFEU prohibits nationality discrimination, Article 157 equal pay, but it's also a general principle applying more broadly, as seen in Royal, Scholten, Honig, or PVS, concerning discrimination against a transgender person.
And the EU can now take specific action to combat discrimination on various grounds.
Yes, Article 19 TFEU provides a legal basis for that. And importantly, the Werner and Mangold case established non-discrimination on grounds of age as a fundamental general principle, even before a specific directive fully applied, which was quite controversial, but showed the power of these principles.
And procedural rights, like the right to defend yourself.
Yes, rights of defense, AMNS Europe, right to be heard, Transocean Marine Paint, duty to give reasons, Halens, Groupement des Fabricants de Papier Peint, these are all crucial procedural guarantees recognized as general principles.
So these general principles act as both a shield for individuals against arbitrary action and a sword to challenge EU or national measures taken within the scope of EU law.
That's a good way to put it. They infuse the legal order with fundamental values.
Okay, so to wrap this deep dive up and help focus revision for the exams.
Right, we've covered a lot of ground.
We've looked at direct effect, how individuals can use EU law directly in national courts. Remember, Van get all loose. The conditions, the vertical-horizontal distinction, especially for directives. Van Dyne, Marshall.
Then, indirect effect, the duty of harmonious interpretation, making national law fit EU law where possible. Remember von Colson and Marley Singh. And its limits, especially in criminal law. Arcaro.
Then remedies governed by national law but needing equivalence and effectiveness. Remember Roe, Comet, and the power shown in Factor Tame.
State liability, suing the state for damages for breach, the Frankovich conditions for non-implementation, and the broader brasserie du pêcheur conditions requiring a sufficiently serious breach.
Supremacy, the cornerstone. EU law prevails over conflicting national law. Costa v. ENAL, Simmenthal, even constitutions. International Handelsgesellschaft. Though its reception in member states is complex. Solange, Factor Tame, recent challenges.
And finally, the general principles: proportionality, legal certainty, equality, fundamental rights, binding EU institutions, and member states acting within the scope of EU law.
Understanding how all these pieces fit together, how the Court of Justice has driven their development, and how they play out between the EU and national level, that's really crucial.
Definitely. Dig into those key cases. Know the names, the basic facts, and the principle they established or developed. That's vital for exam success.
And think about the tensions, the ongoing dialogue between legal systems. It's not static.
Absolutely. Consider the practical impact. What does this mean for someone trying to enforce their rights?
Well, this deep dive was for educational purposes, based on University of London materials, and brought to you by Sinorbit Academy, Sri Lanka. We really do wish you the very best in your exams.
Yes, good luck.
And one final thought to leave you with. Given the ongoing debates about national sovereignty, the rule of law challenges, and the future direction of the EU, how might these foundational principles, supremacy, direct effect, state liability, continue to evolve or be tested in the coming years? Something to ponder.